Good morning again, ladies and gentlemen. Welcome to the ninth biennial Global Conference of the Society of International Economic Law, SIEL. My name is Shen Lin, and I will be your MC for today's conference. Today we will start with Roundtable Discussion 3 of the conference, Investment and Sustainability. Let us welcome the moderator, Professor Julien Chaisse, and the speakers, Deputy Minister Wen-Chen Shih, Miss Emily He, Mr. Greg Tereposky, and Mrs. Danielle Yeow.
Thank you, and good morning, everyone, and welcome to this roundtable number 3, Investment and Sustainability here at the SIEL 25 in beautiful Taipei. So my name is Julien Chaisse, and glad to see still so many people in the room as this third day of the conference. So it's great to see still many colleagues with us and ready for one more, I would say, focused exchange. So to open today, I think it's worth coming back to something President Tsai said in a keynote on Wednesday. She spoke about the need to rethink international economic governance, especially in the face of non-market practices, rising national security claims, and new global priorities like climate change and digital transformation. But her message was not just about trade. It was a broader call for cooperation and shared responsibility. And that's exactly the thread we are picking up today from the angle of investment and sustainability. So before we begin, I just want to add a few more words about our speakers, our 4 experts for today's panel. Why? Because I think it's a very strong panel. They come from different parts of the world and bring very different kinds of experience, governments, academia, and legal practice. But they have one thing in common. Each of them brings huge knowledge, insights, and a sharp view on the questions that we'll be discussing today. I want to have a few words to begin with for Dr. Wen-Chen Shih, because we are very honored to have the Deputy Minister of Taiwan's Ministry of Environment. It's a real privilege to have government officials involved in the SIEL discussions. I think it's one of the strengths of the SIEL to be able to engage with practitioners and government officials. And importantly, she plays a key role in setting the country's climate and environmental policies. And before entering government, Dr. Shih taught, and I think you are still teaching at National Tsinghua University, and you are widely recognized for your work on carbon markets, emissions trading, and the Article 6 of the Paris Agreement. Next, we'll have Emily He, who is managing counsel at Arb Boutique, which is an international arbitration firm based in Brussels. What I find very interesting with Emily, and we already spoke a bit about that, is that her casework spans energy and infrastructure, from nuclear and hydropower to fuel cells and oil and gas. So it's extremely relevant for our roundtable. And more recently, she has been handling disputes ties to ESG obligations and sustainability commitments. Third, we're also joined by Greg Tereposky, who is the founding partner at Tereposky and DeRose in Ottawa. I'll say it the French way, Greg. I hope you forgive me. Greg is very well known because he has been acting as a counsel to respondent states in ISDS arbitrations. Importantly, he has also appeared before WTO panels and Canadian trade bodies. So many of you will also know him indirectly, if I may say, because he's the founder of the Trade Law Guide and the co-founder of another very, very, very important initiative, which is the Investor State Law Guide, two tools which are very widely used by practitioners and academics. And let me add a few words of introduction for my friend Danielle Yeow. We have the chance to know each other for perhaps 20 years. Danielle is a senior research fellow at the Center for International Law at National University of Singapore, NUS, and she leads work on climate law and policy. And interestingly, she also focuses on how law can respond to developments in cyber and tech governance. And in addition to that, Danielle is also a senior advisory with a global advisory firm and a consultant with an Asia-based legal practice. And we agreed not to disclose the name of these firms, but you can reach out to know more about these details. So, as you have just heard, this is a panel with strong experience and very different viewpoints. When we prepared this session, the ideas came quite quickly, I must say. We had no trouble agreeing on where to focus. So we've built the roundtable around 5 main themes, namely regulatory risk, carbon markets, new treaty models, critical minerals, and ESG clauses in contracts. So we'll try to cover these 5 themes, depending on the time. But I think with that, we cover themes which are truly important for investment and sustainability, and themes which are not always the prime focus of academic research. And that's something we did discuss when preparing. What can they bring to us academics in terms of insights from the practice to identify some potential new topics for research, whatever is the stage of your career, all right? So we'll start with the first, regulatory risk and treaty design. This is where legal and policy goals often pull in different directions, to put it very simply. States are under pressures to act, banning combustion engines, protecting forests, setting emissions targets, but investors may see these as threats to their rights. That's the pitch to start. So Greg, I like to start with you, because you've worked on both treaty disputes and domestic trade law. So you might have seen how governments try to defend new rules when they face investor claims. So to get started, the question would be quite simple. What can states do to bring in measures like a ban on combustion engines or stronger forest rules without being pulled into arbitration? And more simply, can treaties, or more generally, can treaties be written to handle this better? Or are we always fixing the problem after it happens?
Well, thank you, Julien, for that introduction, and good morning, everyone. It is a true pleasure to be here to discuss these issues with you. As you will find throughout this panel presentation, there are a lot of areas that need further study and further guidance, and I believe that the combustion engine bans, which have been announced in the press, the industry is aware of them, they're a great example of risk exposure of climate change measures. And the concepts we will be discussing apply to every type of climate change measure that's out there. Keep in mind, the idea with a lot of these measures is to shut down production, industry, or restrict production in industry that undermines the climate. And so very often this really comes close to the line of indirect expropriation, and sometimes will cross that line. In my view, there's a very high risk of adversely affected investors in the automotive industry of bringing ISDS claims against the combustion engine bans. Now, there's some factual background that's really important to understand here. First, Motor vehicle companies are multinational. They have plants in various parts of the world. They're headquartered in not in all of the areas where they have plants. And if plants in other countries other than the headquartered country are adversely impacted, they have a very strong financial incentive to take action against them. It's even more complicated because when you think of an automobile with a combustion engine, the supply chain is incredibly complex. In North America, we have businesses or manufacturers that focus solely on components, they focus solely on engines, and then of course you have the assemblers, the final assemblers who produce motor vehicles. All of these entities have substantial investments in their industry, and all of them will be affected, in this case, in this example, by a combustion engine ban. So, in my view, there is no question they will bring ISDS claims when these bans come into effect. One thing that really complicates things now is up until very recently, there was unanimity in the main countries where motor vehicle manufacturers are located on climate change issues, on banning combustion engines, on transitioning into electric vehicles. And we now know that the United States is taking a step back from this. And why is that important? Because the headquarters of a lot of manufacturers are in the United States. And you can bet they're going to look very closely at their rights under investment treaties if one of their plants somewhere in the world gets shut down because of climate change measures. Now, a couple of other points to keep in mind. Investor-state arbitrations are really driven by private interests that are not constrained by the policy considerations that governments have. So I've spent a lot of time doing WTO litigation, and there are arguments that you could win a case on that you just won't bring for policy reasons. Governments don't want to have the same arguments used against them. So there's this natural filter that tempers what you're doing and what you're arguing. That is gone in investor state. Investors will argue whatever it takes to win their case. And what we've seen, too, is that there's been an evolution in counsel who are appearing in these cases. There's new counsel who have no sensitivity to some of these older issues. And the type of arguments we're running into these days, I would never make. No one in their right mind would ever even try to make them. And yet they're being made, and we have to defend against arguments that, how do you defend against that? Because it's never been made and it's just so obvious. And you can't just say, it's a matter of fact, you can't make this argument. So it's this increases the risk of these claims being made. The entry of third-party funders, which is very common now, reduces the financial risk to an investor to bring these claims. And if anyone has any questions about third-party funding, I'll be happy to answer later. So how do you fix this? Well, the best way to fix it is to have a very explicit and clear exception or carve-out in investment treaties that just permit climate change measures. You cannot claim a breach if a climate change measure has adverse impacts on an investment. And, again, this is a complex issue, and those of you who are familiar with expropriation, there's a lawful expropriation, there's an unlawful expropriation, but in both cases you have to pay compensation. So it really doesn't help that it's lawful. You need more than simply that, and that's where these carve-outs become very important. There is a carve-out that's very interesting in the CPTPP, and that carve-out basically applies to non-discriminatory regulatory actions. So, this engine ban, combustion engine ban, would fall within that. It applies to all engines from everywhere. And then it's got a caveat at the very end, except in rare circumstances. So I suspect, that might be subject to litigation, keeping in mind third-party funding and the private sector view on making every argument possible, I think that will be a very high level of scrutiny. So what do we do? Right now, most of the treaties out there are old school treaties. They don't deal with these issues, you know, like CPTPP does. How do you deal with that situation? And here's an area that is really worthwhile looking into from an academic perspective. We're dealing with this in a lot of different contexts right now, not just environmental measures. But can you restrict or reduce the risk of losing on the merits? So this is a substantive violation of a treaty provision. Can you reduce that risk by giving lots of notice, you know, allowing investors, like in the case of the engine bans, it's great. It's been around for a while. All the industry knows about it, and slowly they can adjust to this. And at the same time, in parallel, they can develop electric vehicle production, and at the end of the day, they're okay. That is something that really needs to be looked into because it's a risk reduction exercise. The other way to deal with it is to deal with it in treaty provisions, but that takes time, and you can't just terminate a treaty. We're experiencing that in North America right now, the transition between NAFTA and USMCA. And NAFTA was terminated, you know, a few years ago, or quite a few years ago, and there's still cases being brought under the NAFTA. We're still fighting those because there's a transition period. So I think those are enough points right now. I'm sure that we'll have a lot of questions, and I will pass it back to Julien to move the panel forward.
Thank you, Greg. Yeah, it's already indeed many points. And I take it as one very important, the one you made on how states can try to reduce risk through treaty design. But the same pressure shows up in contracts. Contracts, perhaps not enough studied by most of the scholars in the field. And that brings me to Emily, because you work very closely with companies in, say, high-stakes sectors, and you see how they handle legal risk in, say, real time, right? So my question to you, and to follow up on what Greg said, is, are the ESG clauses helping manage that risk, or are they creating new disputes instead?
Thank you, Julien. Yes, I do think this is a really important perspective when you're talking about investment and sustainability. We do need to look at the investment ecosystem sort of in the broader sense. It's not just treaty regimes, but in parallel, you also have a plethora of contractual arrangements when it comes to making an investment. You might have contracts with states, with state entities, with business partners, and also all the way down the supply chain. And all of this impacts on the overall picture of regulatory risk. This is all the more so the case when you have uncertainty in the treaty system that investors may try to compensate in the kinds of contractual arrangements that they set up. If you start having the carve-outs that Greg is talking about as well, that can also increase the importance and the emphasis on the contractual perspective of the investment. I am based in Brussels, and so I do have a bit of an EU perspective, although I'm an Australian lawyer. And in the EU legislation, sustainability is actually quite a broad concept. It includes not just environmental factors, but in social, human rights, also governance issues like anti-bribery and corruption. So it does bring in sort of this whole ESG concept as a whole. And if you're looking about trying to accommodate regulatory risk in your contractual arrangements, you have always a number of typical tools that companies can use, contractual tools to reallocate those risks. So you have change in law clauses that might try to allocate the responsibility between the contractual partners for what happens when you have a change in sustainability regulation, who pays for the increased costs of compliance, who bears the risk of delays that may arise in the contractual performance as a result, ways to maybe renegotiate the timing of performance. You may also have representations and warranties built into the contract to ensure that contractual partners are complying with these sustainability obligations. You may also have clauses that can trigger renegotiation or a hardship of the contract if really the new sustainability regulation would change the whole equation of the contract. And you also may have indemnifications or liquidated damages clauses that can impact on this allocation of risk as well. And given that sustainability regulation is evolving quite quickly in several jurisdictions, these tools are really important to build in at the contractual drafting stage. But I also wanted to talk about a whole sort of new area of contractual arrangements that we're seeing in practice. And this is really to use contractual drafting as a tool of positive change to sustainability in itself. This is a way to sort of achieve sustainability goals using the business relationships that you have in a contractual setup. And the idea here is that corporations and not just states bear responsibility for sustainability and for minimizing negative impacts and achieving positive goals. And actually that it's very hard to achieve those goals without businesses building this into their contracts. And this idea has its origin in some soft law innovations that have gone back already for quite some time. You have the UN Guiding Principles on Business and Human Rights. You have the OECD guidelines for multinational enterprises. And following on from that, you have a number of more detailed guidelines like the OECD due diligence guidelines on responsible business conduct that has been followed up by many sector-specific guidelines and the Sustainable Development Goals themselves as well. And these all have a common thread of this idea of due diligence, which means identifying, preventing, mitigating and accounting for actual and potential adverse impacts. And again, you're here talking about those impacts might be on the environment, on human rights, and also on governance issues. And the core idea here is also that it's not enough simply to pass on that contractual risk of sustainability, compliance, and impacts down the supply chain, but that companies at the top of the chain also have to share those risks and to take active steps to ensure that sustainability impacts are monitored, that they support contractual partners in also complying with their obligations, and if you do have adverse impacts, to be a part of the remediation process with your business partners as well. And this started as a sort of voluntary initiatives that companies signed up for who believed or wanted to be seen to be believing in sustainability goals and really incorporate that into their corporate ethos. But it's no longer just a voluntary concept now because you have hard law obligations being introduced in several jurisdictions. In Europe, you had already the French duty of vigilance, and the German Supply Chain Act. And now you also have the European-wide directive, the CSDDD, which I'm sure you've all heard of, that tries to harmonize that sort of approach across the EU. The CSDDD is already enforced, but it has sort of a staged process of coming into effect for companies based on different thresholds. It is also under renegotiation or diluting in several key respects with the omnibus legislation, which is under negotiation as well. So there still remains some uncertainty, which goes back to the point of regulatory risk. I think that we don't know what the final sort of legislation is going to look at, but you still see some of the key factors that are going to influence the way investors set up their contractual arrangements. And one of the key points here that comes into play for the contractual arrangements is that within the CSDDD, there's obviously the obligations of due diligence to perform those exercises as a company, but there's also an obligation to seek contractual clauses contractual assurances from your direct business partners to ensure that those sort of obligations flow down the chain of activities of those entities. So when it comes back to this idea of regulatory risk and where these risks are being allocated, it's not totally clear how this all plays out in practice yet. And I think that can add to the uncertainty of what these contractual arrangements are going to look like, whether you end up with more certainty about where risks are lying, or in fact, whether you multiply those risks. As a disputes lawyer, I do see plenty of risks of disputes arising from these arrangements, and we are starting to see some of those disputes emerge in arbitrations. We're starting to prepare ourselves for scenarios where you have sort of multi-contract and multi-party disputes. If you have these contractual assurances that are built into the chain of activities, it's very important how those clauses are drafted, how they flow down from one level to the next, who is obliged to do exactly what, and how you really give substantive content to some of these due diligence obligations. What does it mean to do due diligence? What does it mean if you don't comply with those obligations? What are the consequences? What are the remedies? What's the causation link between the damage that might be caused by an adverse environmental or social impact linked to the failure to conduct due diligence? So you have some very interesting questions, and also an overlap potentially with domestic litigation in courts, because this legislation also provides for civil liability provisions as well. So a lot of food for thought, and maybe not a clearer picture, but a lot of interesting questions.
Yeah, Greg, if you want to add.
Just a quick follow-up. The points that Emily's raising are very important ones, and from the perspective of defending investor state claims, they will become facts on the record. All of those clauses will be subject to a discovery process or a production process, and they will be used to help lay the factual foundation of how aware was the investor of these issues, how were these issues addressed in the investor's commercial operations, and that type of information can be extremely helpful, especially in cases where the treaties that you're dealing with are dated and do not deal specifically with these issues. And it goes to this transitional point I was making earlier. Thank you.
Can I quickly follow up as well, just to add a further complexity there, that you can also have disputes concurrently under a treaty and a contract, and I have had a case like that where the investor sues under the treaty and under the contract at the same time, and so there's a cross-relevance there as well.
It's a very good discussion. We have heard now from both the treaty and contract sides. Wen-Chen, from your position in governments, and Danielle, from your work on international legal policy, if either of you would like to add any insights, I think at this stage we'll be very glad to hear them. Wen-Chen, perhaps first? Danielle, please.
Yeah, no problem. Thank you very much for the invitation, and really fascinating, a very useful overview of the treaty side and the contractual aspect. So what I'll deal with is just picking up a little bit on what Amy mentioned, which is the aspect of private environmental governance and what I call hybrid private environmental governance, because it's seeping into what we see in legislation. ESG is kind of a dirty word now. I kind of prefer to use the word sustainability. And, and sustainability is really a core consideration for businesses and investors alike. And so the question was asked for me to speak about this morning is really whether we can see, the ESG framework. Is it an increasingly contested or an increasingly or more predictable regulatory risk landscape for companies and for investors? And my quick response is a little bit of both. And it's a question of whether or not the scales are tipped more, in your view, in favor of a more contested era. But I think in the long term, we're looking at more harmonization, more predictability, and ultimately a better risk mitigation and assessment by investors. And why do I say that? On the part of predictability, and I think Emily has also mentioned this as well, more and more countries are coming out with mandatory sustainability reporting disclosure frameworks. And for some, they extend into the due diligence. So it's a little bit beyond mere disclosure and reporting. It actually requires, under the due diligence framework, additional steps to be taken, not just by the top line companies, but also down your supply chain up and down. But what we do see is, despite this difference in scope and coverage, they are all kind of moving in the same direction. And I think it's a question of speed where everyone will eventually get to that point. And you see that in Asia, a lot of traction in Asia. Singapore has that, China has that, Japan, Korea, all in different shapes and sizes, but all, as I said, moving in the same direction. A clear trend towards something that's a more comprehensive, more mandatory, and also driven by a desire to align it with international best practices. So it's not each state coming out with its own, so to speak. There may be some variations, but there's a clear inclination and a clear intent to move and align with international best practices. And that means more harmonization, more predictability also for the investors. That's one key point. Another key point is that even among the different standards, we're looking at ISSB, GRI, TCFD, even the EU sustainability reporting standards, even within these different competing standards, so the companies will actually required to report to one set of standards in jurisdiction A, but another set of standards in jurisdiction B. Can you imagine how crazy it is and the compliance costs? And so even among these competing reporting standards, they recognize that. And so even between them, there is a clear move and clear attempts to collaborate, to cooperate, to map and to align for some coherence among the different standards so that the company ultimately produces one set of reporting data that meets the requirements of different jurisdictions. So I think that's quite an important point. And the last point I want to highlight in terms of predictability is the importance of technology. And this is playing an increasingly crucial role. The increasing availability and adoption of advanced technologies, including AI, data analytics platforms, empower companies to collect, to process, to report these data in super quick time and with great accuracy. And that technical support is very important. And improved data access can also enhance the investor's ability to predict and to model the financial impacts of regulatory changes relating to their sector. Governments recognize this as well. And here I just want to bring up the example of Singapore. So in Singapore, we in 2023 launched what they call Gprint, which is green print. Right? It is a seamless ESG data collection platform, integrated digital platform for financial sectors to collect, assess data, and to use it to support the sustainability initiatives. This has been expanded, it has been broadened, and in May of this year, so it's very, very fresh, the green print, is called Gprint, but it's actually pronounced as green print, don't ask me why. It unveiled the world's first nationwide utility that would enable companies, especially SMEs, to automatically generate their basic sustainability matrix. All right, so basically what it means that companies can automatically convert their utilities data, so electricity, water, things like that, into basic sustainability metrics, scope 1, scope 2 emission values, for instance, on this platform within minutes and zero cost. So that's extremely powerful. It's a game changer as far as sustainability reporting goes. And high integrity sustainability reporting data is critical for businesses to formulate effective transition plans for decarbonization. So that's a quote from Singapore's Ambassador for Climate Action, Ravi Menon, and I couldn't put it better myself in terms of the critical importance, a game changer where technology is. Having said that, as I mentioned, that indeed still is a very contested field. And Emily mentioned this as well. There's regulatory fragmentation, there's divergence. There's one major jurisdiction we talked about for a lot yesterday that seems to be beating to the beat, walking to the beat of its own drum, whatever you call it that way. And it's a big economy. So what are companies supposed to do in this very fragmented framework? Even among jurisdictions like EU, which has a very, more advanced, should I say, more progressive model, as you say, there's been pushback, there's been lack of clarity, there's the omnibus has had had to shift and adjust. And even a few weeks ago, there was massive confusion over the withdrawal of the EU Green Claim Directive. So is it on, is it off, is it on, is it off? So that's utterly confusing also for businesses. Added to that, the politicization of the ESG sentiment and anti-ESG sentiment. Investors' expectations are also evolving. So all this is contributing to this, what we call investor climate tension. So I'll just stop there. And basically my observation is you have indications both ways. It's take your pick, whether you think it's more predictable or more contested.
Okay. Thank you very much, Julien, and all my dear panelists and all the ladies and gentlemen. Good morning. It's a great honor to come back to the academic environment where many of the debates are not only inspirational, but it could bring some policy significance to people working in the public sector. I think initially my response will be very similar to what Danielle has been saying, that the regulatory risk, are they becoming more predictable or more contested? I think it will be both. For starters, both the examples raised by Danielle and by Emily looked at one type of measures. Well, if I can say that, a decarbonization measure, company corporate reporting, like transparency aspect. But for policies that government adopt to reach a net zero goal, there's a wide range of decarbonization measures that's being adopted by many different countries with different levels of development and different levels of regulatory landscape. So I would say that, first of all the parties under the Paris Agreement are currently preparing their nationally determined contribution under the Paris Agreement, which should be handed in by the end of February this year, but a lot of countries missed the deadline. But when they are in the process of updating a more ambitious decarbonization goal, they would be followed by many of the policies that helps to reduce countries' emissions. So we are going to expect a lot of decarbonization measures, such as the phasing out of combustion engine, as Greg has mentioned. But we have to bear in mind that, for example, the feed-in tariff for renewable energy as a policy to support renewable energy has been a long-developed policy tools in developed countries, but probably not in developing countries. So we see, maybe many of you are familiar with the Spanish case where the withdrawal of favorable conditions of renewable energy rate attracted many arbitration cases under the ECT, and some of them Spain win, some of them the Spain lost. So we do see cases where some of the decarbonization policy is being altered, and that affect investor interests. But when these policies are used by developing countries, they would only enhance their level of support. So, my view is that for investors that tries to look for investment opportunities in countries with a more ambitious emission reduction goal, coupled with decarbonization measures, we have to look very closely on the development or the overall context of that particular country, in the sense that different types of decarbonization policies operate at different national circumstances. So it's predictable in a way that nearly all of the countries, apart from one, who is backtracking. But at the same time, different countries, when they pick different policy tools to reach that goal, their conditions might be like ticking at some point. That is the reason why I say it's both predictable and it could be more contestable at the same time. So that's my brief introduction.
Thanks. I suggest that we now turn to our second topic that I know that many of you in the room are closely following. This is carbon markets. And this connects directly to Wen-Chen works both as Deputy Minister of the Ministry of Environment and academics. So one case that raised questions is the Koch versus Canada case, where the tribunal took a view on emission allowances that, to say the least, surprised many observers, right? So Wen-Chen, you flag this as a case worth watching. Why do you think the tribunal got it wrong? And what kind of risk does this create for countries trying to put the Article 6 of the Paris Agreement into practice?
Well, I think for starters, I actually think the categorization of emission allowance by coal under the arbitration is not that is correct, I think so, because from a carbon market perspective, we do see two types of units that are being traded on the carbon market. One is the emission allowances. That's very typical under a cap and trade system, where the government sets a cap for a participants that are compulsory to take part in the system, and then you distribute it, the emission allowances to these installations that emit greenhouse gases. So that part of the market where emission allowances are traded are heavily regulated by cap and trade regulation. I think that's one of the reasons why the whole tribunal thinks that under that type of emission trading system, emission allowances is heavily regulated by the legislation. And as we understand in the coal cases, that originated from Ontario opting out of a cap and trade system. So from the language of the cap and trade legislation in Ontario, the tribunal, I think quite correctly, identify the major characteristics of an emission allowance that's been heavily regulated. But another issue is that because the tribunal also state that whether emission allowance or property would depend on the local legislation. So we see a lot of cap and trade legislation, both nationally and locally. In California, the Californian cap and trade regulation actually states that allowances and credits are not property. So the Canadian law states that. But in New Zealand, I think emission allowance are personal property under their personal property law. But I have to verify that because I read it from a textbook. So you do see local legislation that mandate cap and trade gives different characteristics of emission allowance. But most of the legislation do not touch upon that question. So the Ontario cap and trade legislation is one case in point. But from the carbon market perspective, what they are heavily traded internationally under the voluntary market is what we call a carbon credit or carbon offsets, which are generated from projects that are meeting a certain criteria set by different standard setting organizations, be they under international treaty regime, the UNFCCC, or under like NGOs, or even under domestic crediting system. So carbon credits are another type of what we call the assets, where they are generated by private parties. They are certified mostly by private organizations and issued by private organizations. So the way that they are not that heavily regulated, and they are not under the discretionary power of the organizations that issues them, could make the whole argument inapplicable in carbon credits as opposed to emissions allowance. So in the sense that when we are looking at carbon market, initially we do have to understand the differentiation between these two types of systems that's been operating at the local level, California or Quebec. At the national level, for example, Korea has a ETS, New Zealand has an ETS, or at the regional level, EU has a cap and trade, or even under the Paris Agreement. At the same time, we do see many carbon credits that are being traded in the voluntary market. And the way projects generate carbon credits actually would interact very closely with investment, because some of the typical projects that generate credits, for example, you invest in a renewable energy power plant. That would be a very classic FDI, and that's been under regulation or under the scope of any BIT. But also, we see a lot of projects that generate carbon credits. For example, you distribute clean cook stove to household, rural area, so that the emissions can be reduced by not burning woods, but they have clean cook stove that use gas. At the how do you define that as an investment? Because under coal, one of the reasons why it is not an investment is that the KSNT only buys and transfer emission allowances. So it is stated that it's only a cross-border trade rather than an investment in itself. But some of the carbon offset project could probably run that way. There will only be inflow and outflow of capital rather than an actual investment. And some of the project, for example, a forest conservation project where you hire local people, you hire local experts to enhance the forest management of a forest in a developing countries. Would you categorize that as an investment? So I think from a carbon market perspective, investment legal regime and host country regulatory discretion and investor protection really needs to take into account the differences between different type of units that are being traded on the market, as well as some of the institutional aspects that are authorizing this type of trade. So that's I think I'm running out of time because I see the 2 minutes flat like 5 minutes ago. So I will stop here. If any audience is more interested in Paris Agreement 6, then I'll come back to that.
Thank you. Yeah, we can come back on this big topic in the Q&A. But perhaps let me turn to Danielle, if I may, because your work closely look at how climate commitments connect to international law and domestic legislations. So do you think, Danielle, that investment law is starting to take those obligations seriously?
It's a big question, and it's unclear. I can hear what I think it should do. I don't think that's the point. So I think let's take the example, and I totally agree with what Minister has said. It's an area ripe for research and writing. And I just want to add a little wrinkle to what you said about voluntary carbon credits, because another wrinkle is really what is the nature of those, even if it's a property. Tangible property, intangible property. So there's work done on that. I'd be happy to give a reference to a paper I was working on, a white paper looking at this question. UNIDROIT is looking at this question, and ASIFMA, which is Associated Securities, are also looking at the question. And why is this important? Because it goes down to the question of the security, the financing, the mortgages, whatever you call it. And that goes directly into the impetus for investment, which is necessary for climate financing. So it's a big circle and loop. But I didn't want to add a wrinkle, but I think that's quite important since you raised it. And coming back to your point question, Julien, I think let's take the example of corresponding adjustments. And everyone knows what corresponding adjustments mean in this context, or I'll give a quick 1 second description. So in the context of Paris Agreement, Article 6, the carbon markets, after many years of negotiation, finally they agreed, is it 10 years, something like that, they agreed on the rule book to operationalize Article 6. Article 6 is the provision that allows for this carbon market in trading. And why is this important? Because for many countries, NDCs, the National Determined Contribution, I would say majority of them have said they can't meet the NDCs unless they are able to resort to carbon credits. So it's absolutely vital that you have an operational Article 6, which means you need to have operational rules, you need to have clarity so that investors will come in, put into this project, solar farms, whatever you call it, generate these credits which can then be sold. So those are then, so once the credits are, so let's say a solar farm, investor puts in money, it generates renewable energy, creates a number of carbon credits. It's calculation, I'm not going to go into that. that can be what we call ITMOS, right? Internationally transferable mitigation outcomes. That can be then sold to another country or another company to meet their own commitments. When this is transferred under Article 6, there's this concept of corresponding adjustment. So the host country A, when you sell it, you have to add that to your account. You can't claim that as I've reduced my emissions, and then you sell it, and that country also claims it as its emission reduction. That's double counting. So to do that, you have this idea of corresponding adjustments. If you sell 10, you have to add 10 to your own, right? So of course, for countries, it's a dilemma. Because if you're not meeting your commitments, the temptation is to, I'm just not going to do that, right? Here comes the investment question. If you're an investor and invested to that, and the company, if the whole state doesn't meet its obligation, or contractual or otherwise, because many of these are also backed by state-to-state implementation agreements. So for example, Singapore has that with Ghana, Papua New Guinea, and that provides the confidence and the basis for companies to come in, enter into contracts with the host government to set up those projects and to be able to sell. That's a huge investment. So if country A, as a host country, decides, well, I'm not going to do that, then your investment is worthless because you can't sell it until 6. So it's a clear investment question, right? So how would that do? So you have, therefore, a down attention between the states. I can say, oh, it's a regulatory measure, I need to do this to meet my own obligations. And then you run up against, at the same time, a commitment, I would say an obligation under the Paris Agreement to do that. And the whole structure, negotiated, very carefully constructed system is not going to work if countries are just going to change their minds and not make the corresponding adjustment that they're supposed to do. So you can imagine it's a bit crazy, right? So if you can take, well, so you have these two very important policy imperatives. You want to preserve at the same time regulatory autonomy to do things which are necessary for your public, for your interests, but at the same time you have that. So how do we deal with that? And the question is, in this case, concepts of systemic integration, coherence within Paris Agreement, so on and so forth. Some would argue that you are looking here at an Article 6 obligation vis-a-vis a non-binding NDCs. We mustn't forget that under the Paris Agreement, the obligation is procedural. You have to put up an NDC, but it doesn't actually say that you have to have a legal obligation to meet those NDCs. Now, Professor Minarope at Durham argues differently. She argues that actually, because of the global stocktake, because of the ratcheting, it's actually now a substantive binding obligation. But that's not the view of everybody. So I could argue that one's a legal obligation, one's actually not. So how do you do that? So again, as I said, I don't have an answer. I think for the proper integrity of the system and the coherence, concepts of systemic integration, tribunals should actually recognize that as an obligation. So it's not used as a defense, ironically, by the state. It's actually used as a weapon by the investor to hold the whole state to account. So I'll be happy to hear your views.
Oh, fantastic. And Greg, feel free to add a thought if you'd like. You know this space very well, not least because you are a wonderful Canadian, but you have been handling many of these kind of cases.
I'm just going to limit my comments to a very narrow issue. And earlier on, I made a comment that a lot of this background material forms the facts in an investor-state arbitration. And one of the things that's becoming very clear is that those facts, and starting with Emily's contract points to the facts that we've just been discussing, are in dispute. And they're complicated, and it's very hard to get a grip on what are the facts that underlie a case that are relevant to determining whether there's a breach and also what the magnitude of damages should be. And so I think, here's an example of where you need different layers of experts when you're dealing with these cases, and all investor-state arbitrations have experts with them. And in both, the points that Emily made and the points that were just made, you would need an expert to unwind what all of those facts were. And that might have been a factor in the outcome of the Cock v. Canada case. Anyways, I just want to leave that point with you. These cases are getting more complicated, not easier.
Well, thank you all. Look, we can now move to our third theme, which is new treaty models and other approaches beyond BITs. Because a lot of the earlier discussion has focused on how to adjust existing rules, but there is actually a lot of work being done to build something different altogether. And these new tools, some binding, some not, are being tested by governments, negotiators, and institutions. So I think it's important to see a bit what's happening here. And I'd like to get back to Danielle on this question, because you have written about this, and you brought it up in our preparation discussion. You mentioned the test principles, the ACCTS, and some ASEAN efforts, which are very important for the region and beyond. I think it's important to discuss them. So in short, the question here would be, what do these newer or non-binding instruments offer than that traditional treaties, BITs, may be missing?
Do I have like 1 minute? How much time do I have? This is a big topic. But there's the new, I would say there are three categories. One is the newer binding agreements, the new form of FTAs, like the second protocol to the ASEAN, Australia, New Zealand FTA, for example. Those are the new form. Second, there's the non-binding, like the IPEF, the Green Economy Agreements. Third, they're not treaties, they're not agreements, they're actually more principles, like the G20 principles, the TESS principles, the Vilnius framework. So there are three categories, all of them new forms of governance, so to speak. So very quickly, if you look at new forms like ACCTS or the second protocol to the ASEAN, ASEAN, Australia, New Zealand, UNSPTA FTA, what they try to do is to actually put sustainability up front and center. And so you have a focus on, for example, removal of tariffs on environmental goods and services and things like that. The second category tries to create a new form of governance, non-binding, collaborative framework, focusing on 21st century issues, circular economy, collaborative efforts to, for example, working on the carbon markets, eco-labeling, things like that, and bringing in public-private partnership in a multi-stakeholder exercise. And then you have the principles like the G20 principles on trade and sustainable development that was released last year. And then you have the TESS report, which is the International Legal Expert Group on Trade-Related Climate Measures and Policies, where they look at the principles of international law that are relevant for the design and implementation of trade-related climate measures. And then, of course, you had the Vilnius framework that was actually, I think, Dan Esty at Yale University did that during his stint with the WTO. And they seek to integrate environmental sustainability into the core of international trade agreements and organizations. So the last category is more like upstream rather than downstream. You already factor that into the way you design your systems. So these are the three broad categories. What are the advantages? They focus on sustainability, central and integrated, as opposed to being, by the way, secondary issue in the old form of in the traditional FTAs. They provide for flexibility and adaptability. They're not binding. You can join, sign off, and whatever, as compared to something that's legally binding and more rigid. Instead of a very narrow focus on investor protection, you look at it a more collaborative, problem-solving attitude to look at complex modern challenges, critical supply chain issues, digital economy issues, emphasis on labor and environment, and really working, as I said, extended reach to non-state entities and eco-labeling. So it's quite a paradigm shift in how the issues are looked at. Perhaps during the Q&A, if there's more time, we can go into the specifics of a case study like the Green Economy Agreements.
Thanks. And Emily, let me turn to you on the contract side, are you seeing the same kind of change in how dispute clauses are written?
Yeah, that's really interesting, Julien, because I do see some convergence or a sort of a match in this shift towards a more collaborative approach that Danielle has referred to, just entirely separately in the contractual context. So some common threads in the way that sustainability is now looking at being addressed in the contractual context. Some of those points are this idea of a joint vision. So you have in the treaty context the joint vision, or the idea of a joint vision between the investor and the state about the importance of sustainability, but you also have that in the contractual context when you're looking at making voluntary commitments. So the two parties to the contract are both pledging to, for example, meet certain net zero requirements, or perform their contract in a way that minimizes waste management. So really this meeting of the minds to achieve a goal together. And you can see the specific way that these things can be drafted in an initiative called the Chancery Lane Project, which you may have heard of, which has more than 100 model clauses which help achieve climate-related objectives and can be built into all sorts of different kinds of contracts. They get really specific into certain sectors and certain contractual arrangements, and each of these model clauses comes with advice or commentary about how you integrate it into the contract. So that's really one way that you can build the sustainability in with this joint vision. Another overlap to what Danielle mentioned was this idea of shared responsibility. So sustainability, and also that Greg mentioned when he's talking about the carve-out there, that there's a shared responsibility also for the contractual parties. There's another model clause initiative that really illustrates this well, is the ABA model clauses, which are focused on the issue of labor in the supply chains, human rights in the supply chains. And their first set of model clauses were released in 2018, and it was really built around a representations and warranties approach. So building human rights into the supply chain, but the risk ended up mainly with the supplier as opposed to the buyer. And after they released these clauses, it was realized that actually this maybe didn't achieve what they would like in terms of the risk allocation and the recognition that actually the buyer conduct has a big impact on the sustainability or the human rights perspective. And they released a new set of clauses in 2021, which shifted this risk from a representation and warranties approach more to this due diligence approach that I was talking about before. So this is more, again, the burden sharing moment, and you have those clauses undergoing a third stage of review right now, also taking into account that we have more and more hard law legislation about having these kinds of clauses in place, so they take on even greater significance. And the third link that I see with some of these initiatives that Danielle mentioned is this problem-solving approach that she referred to, or like a non-adversarial approach, which is an interesting approach when it comes to contractual arrangements. But it's really this emphasis on, say something goes wrong in the contract, there's an issue, a sustainability-related issue, for example. You have multi-tiered or several steps in a dispute resolution process to work through, and the focus is on dialogue, on having grievance mechanisms in place to try and catch issues early, and escalation options, potential for remediation efforts to go underway. And the idea is, rather than terminate a business relationship, that you try to work together to solve the problem and continue that relationship while also achieving your sustainability goals. So this is a very worthwhile objective, and we'll see in due course how it manages to achieve the positive outcomes that it's seeking to. You do have some complexities when it comes to the traditional contractual dispute resolution that we have in place, for example, in arbitration, which is a very consent-based mechanism. In some of these clauses now you have different stakeholders involved that may not be parties to the contract. How do you work that into, a typical arbitration proceeding? There are public interests at stake. How does that come into play with the traditional confidentiality of an arbitration proceeding? When you have these sort of remediation plans in place, and some clauses foresee that an arbitral tribunal would be asked to make orders about remediation, but traditionally an arbitral tribunal is functus officio after it has issued its award. So how do you go about enforcing or implementing a remediation plan that would follow an award? These are all some of the complexities that arise, but I think there are still a number of common threads you see in the investment and the contractual landscape here.
And for any of you who would like to add a final point here, Wen-Chen or Greg, perhaps, or should we move on to the next topic? Yes? Yes, we keep an eye on the time, don't worry. That's my responsibility. We are good. There'll be time for Q&As. We'll skip we won't come back on the ESG. I'll tell it to you right now. So we have more time for the critical minerals and the Q&A session, all right? And so, yeah, that's the fourth theme, very, very important, in particular in the region, critical minerals and the green transition. That's, of course, a topic that has got a lot of attention in policy and climate talks. Again, I find there is not enough academic research done on this. But also, I think in terms of legal practice, especially on the investment side, there is still a lot we don't know. The rules are not clear. The contracts are often complex for the few we can have access to, right? And the cases are only starting to emerge. But it's important we know it because the pressure is global, but it's especially strong here in Asia, right? So we have to discuss this. Let's start with Danielle, back to you, because this goes straight to your recent work. How should governments handle ESG goals, national security concerns, and this increasing demand for critical minerals? All in the same project very often.
Yeah, thank you, Julien. It's a difficult issues. It actually, this is where you had the intersection of sustainability, ESG obligations, this concept of just transitions, this concept of national security, but in resource extraction projects, and it's really complex, a policy challenge for governments today. So I'd like to just to confine my remarks to the context of critical transition minerals, which talking about green transition. And that's particularly important to the energy transition. There's a lot of geopolitics involved, but I want to just focus on how can governments deal with this? What are some of the ideas that have been seeded? And what is the role of the various players in this field? And why do we even have this concern about critical minerals? Because as a result, it's a really vanilla resource extraction project. And that comes with the downstream issues of environmental degradation, pollution, impact on indigenous local communities, and the question of the equity and distribution of the wealth from the extraction, right? Are you just a commodity provider, and where is the benefits distributed up and down the value chain, and how much does the country that actually hosts these minerals, what benefit do they derive from this? Do they derive fair and equitable benefits? So these are all concepts that are mudding, I wouldn't say muddling, because they're actually very important considerations. And how does one address this to ensure that the global demand for these kind of minerals do not come at the expense of the environment or local communities, and do not come at the expense of I would say, laborers and employees who may lose out in this just transition journey. And how can governments do that to pursue these opportunities offered by global energy transition, especially if you're resource rich, at the same time doing it in a manner that will support sustainable development and deliver in a manner that is responsible through a fair and just value chain. So you're trying to achieve many objectives at the same time. So that's extremely difficult. So in the context of the Paris Agreement, the climate change, obviously this concept of just transition is just beginning to gain more traction, more attention. If you ask me what the concept means, it means different things to different people. And that's still being discussed. But fundamentally, the one core and principles there is that no one is left behind. And the fair labor practices and so on, the human rights elements are all taken into consideration. So this is in the same context that the UN Secretary General established this high-level panel looking specifically at the issues of critical transition minerals. And this was really a response to call by developing countries for action in this field. How did you develop a set of what I call global, it is described as a global, common, voluntary principles on issues which are key to building trust between governments, communities, and in industry, to enhance transparency and investment, to ensure just, equitable management of sustainable, responsible, reliable value chains for critical energy transition minerals. So it's a big ask. And so the report came out last year, and it's called the Resourcing the Energy Transition Principles to Guide Critical Energy Transition Minerals Towards Equity and Justice. It's a whole, I think even the title was negotiated. But what ultimately is important, within the time available, I just want to flag that the report proposes a set of 7 guiding principles and 5 actionable recommendations, designed really to meet these objectives of trust, equity, so on and so forth. And collectively, they will empower communities, create accountability, and so forth. So very quickly, the 7 guiding principles talks about human rights being at the core of all mineral value chains, talks about importance of the maintaining integrity of the planet, environment, and biodiversity. So let's not forget, biodiversity is an increasingly important issue in the larger narrative of health of the planet. Justice and equity must underpin your mineral value chain, and you must foster development through benefit sharing, value addition, economic diversification. Your investment, your finance and trade must be responsible, and it must be fair. And then the question of good governance, and again, the question of importance of multilateral considerations. So when you translate that into the actionable items, they include even recommendations to create what you call a global mining legacy fund, and to develop a global traceability, transparency, and accountability framework. Now, this is a report, the follow-up hasn't taken place yet because the panel hasn't been in panel, there's issues with the UN budget funding and so on and so forth. But when it does come into play, I think it will have implications for how governments will look at this issue in terms of the contracts, the concessions, the domestic regulation. For companies, they will look at it in terms of their contractual arrangements, their corporate responsibility. For financials, multilateral development banks, they might want to look at this as part of the criteria for funding and financing, and of course, the role of civil society. So we can get into that, but there's one attempt in a very specialized area to try and meet these objectives.
Wen-Chen, let me bring you in next, perhaps, for some very final comments before we turn to the Q&A. And from your role in governments, are developing countries gaining from this wave of green investments?
Well, I think I'll promise I'll be brief. Maybe I'll just add a little bit on the critical mineral issues, because Danielle talks about that in the context of resource extraction as raw material. But nowadays, we see that many of the mineral are actually extracted from e-waste. So, or a lot of countries are trying to, not importing raw material, but try to, extract more critical materials from e-waste. And from my understanding, I think waste management is a large industries that do many foreign investment. So I don't know whether that would be another trend where taking into national security considerations, some of the waste management investment that are dealing with extracting critical minerals from e-waste could one day become affected for several reasons. So I'll just add that. And coming back to the question on green investment, I think developing countries, maybe I'll just focus that on from a climate perspective, many developing countries are expecting climate finance from, for example, a carbon project or from the opportunities that might be developed under the Paris Agreement under, a market approach. For one thing, if the climate finance or green investment in that area do bring extra capital and green or clean technology to the developing countries, then I would say that it's really a plus. And that would also create a very enabling environment for investors that focus on sustainability investment, not only in technology, but also in terms of capital. But on the other hand, as I think the whole panel was discussing some of the risk that can come from not only, mainly from regulatory change. So some of the green investment or climate investment might come with conditions, or the conditions that, for example, Danielle explained on the corresponding adjustment concept under the Paris Agreement style of bilateral cooperation to generate credits. But the reason why the Paris Agreement took a long time to finalize the rules on Article 6 focuses on one single issue, whether host government can revoke authorization to give corresponding adjustment. Because when projects are undertaking initially, the host country sometimes just give authorizations that, well, I'll promise that I'll do corresponding adjustment in 2 or 3 years, because that's when our NDC period ends. And there are a lot of debates from investors' point of view that host country might, toward the end of their NDC period, find themselves doing insufficient domestic mitigation effort, and they really need the credits there from the project to meet their NDC. So whether it is legal to revoke the initial authorization is a crucial issue. And if we are looking at these increasing green investment opportunities with conditions, and the conditions might change or the condition might materialize in a few years, that could bring more unpredictability. So in that regard, I think Greg mentioned transparency is really a good weapon to be used. Well, not weapon. I think it's a good safeguard. If, for example, the host government would like to contain some of the flexibility or discretion, then they would have to flag that very early. There are, they come with condition, and what are the conditions? And then investor would also have to build some of their risk reduction through, as Emily mentioned, contract, because some of the project would have a emission reduction purchase agreement between the developer and the some of the project investor. So some of the risk can be reduced either from the host country side or from the investor side. So that's my thoughts.
Thank you very much. I will just add a small thing, which is that there is also some ongoing UN work on United Nations work on critical minerals, and there is a working group that was set up a bit more than a year ago, on which I have the pleasure to sit, and we are working on a white paper that will be released later this year. That will cover a number of things, such as the guiding principles and how they intersect with trade and investment rules. So something to also keep an eye on for all those of you who may be interested in this very important topic. So that brings us to the final part of our session, the Q&A. I think we have around a bit more than 10 minutes for that. We've got a room full of experience. And if you'd like to ask something, please, you know the procedure. Raise your hand. I think we could try to collect a few questions, 3 to start perhaps, and see whether there is another round. That would be 5 questions for the first round. And I'll start with the ladies and Agatha, because she put so much effort in the organization of our conference.
Thank you very much. Thank you so much for this panel. I have a question perhaps for Emily and Greg, and it's to do with contractualizing of investment disputes, and there's a passage in Granada, Private Power Against Granada, about contractual clauses closely mimicking the substantive obligations typically imposed on host states by VITs. Do you see that this is where ISDS might be going with all the sort of criticism that is leveraged against the system? The relationship is not going to go. There has to be some sort of a legal relationship between an investor and a state. Is that? Will there be more? Emily, are you seeing this in your practice, for example? So that's the direction of my question. Thank you.
A second question, please.
Thanks, Tracy Epps from New Zealand. Just a question for Greg. I was just interested in the comments, and I guess also the Minister, your comments about transparency as a potential, I guess, sort of mitigation against the risk of investment claims. And I just wondered, like, if you had any, I guess, advice or just thoughts, for countries who are really trying to promote investment. So on one hand, you have those investment promotion motivations where countries are really trying to get new investment in, and how do you balance that with at the same time providing that transparency, but not undermining, your promotional activities at the same time?
Thanks. I think there was a third question here.
Oh, thank you so much for this very fascinating discussion. I have two questions, one for Greg. So you mentioned third-party funding, and I wonder, in the context of this kind of sustainable related or renewable energy related investment dispute, does any kind of third-party funders involve, or do you see whether the third-party funding would trigger more cases in this kind of dispute? And second question would be more general. It's about CSDDD. So do you think that the implementation of a CSDDD would to some extent, like strengthen investors' duty to do the due diligence, and how the CSDDD would operate with the existing CSR-related clause or the Sustainable Development chapter in current bilateral investment treaty or other kind of economic agreement. Thank you.
And two more. So there is Elizabeth.
Thank you, everyone, for a really wonderful panel. Sorry, my name's Liz Sheargold. I'm from Monash University. My question is primarily for Danielle. On the green economy agreements, I agree with you that the sort of collaborative approach they're taking is a bit of a new paradigm in these treaties and is really fascinating. I'm wondering if you could talk a little bit more about what you see the actual value of the written agreements being, though, when the agreement is non-binding. And, for example, looking at the Singapore-Australia Green Economy Agreement, it does have a really important range of collaborative activities, lots of different regulatory bodies, as you said, public and private actors. But what does the agreement itself add to that beyond just having these regulatory bodies, say, in shipping or hydrogen or standard setting, just cooperate with one another? Is there a real value to the treaty itself? Thank you.
And there was the last fifth question. Alex, please.
Thank you, Alex from National Taiwan University. So my question is mainly to Danielle, but also probably relevant for Emily as well. So another of my primary research focus is on corporate governance and security regulation. And in those areas, those ESG issues and sustainability related issues are like the most trendy words there. But there is a huge concern against the idea of ESG and sustainability to the extent that the idea per se is great, but its implementation is just not workable because it's just too difficult to create a valid methodology to account for the concept of sustainability. Nowadays, we talked about from E to S, but it gets increasingly difficult to measure the social performance of each individual project or corporation. Even within the E itself, there are so many dimensions. It's probably easier to measure the carbon emission because there is a more consistent formula there. But how about other environmental aspects? And how do you account for the weigh and balance between different environmental factors and social factors? And nowadays, you also see, for example, geopolitical, national security, all these kind of measures. So my question would be, is it really feasible? Because Daniel mentioned the trend toward a more predictable sustainability roads. I'm just curious how you would comment on those criticism against the potential of sustainability washing if we simply goes along this way. And also the question to Emily would be, is there a feasible contractual way to really account for these different dimensions of sustainability issues that need to be taken care of? Thank you.
Thank you for these very good questions. Can I suggest that you answer to each or the ones you prefer, one after the other? And we could start with Danielle, then Greg, Wen-Chen, and Emily. And since we have 5 minutes left, that means a bit more than 1 minute for each of you.
Thank you. I just addressed the question on the green economy. And in fact, this is a question I've asked myself earlier. You know, if it's non-binding, what's the value of it? I think Pasha Xia has written about it, right? He describes it very well. It's a catalyst, and it's an attempt to, you know, be a pathfinder, a catalyst, get some new green thinking in an area where you may see some dysfunctionality and an impasse in global normative trade rules, so to speak. So I think it's an attempt to plug some gaps in the world trade system in a way that is still consistent with existing trade rules. And so that's how I would briefly describe it.
I've got a few questions to reply to here, so if I get them wrong, my notes are horrible. Please correct me on them. I'm going to start with Tracy on the transparency issue. Now, I see transparency becoming relevant in the transition period before we get the texts of the treaties fixed. And what that generally means is that these are investments that are already in place. So they've already been attracted, and it comes down to mitigating your risk of getting a claim brought in the future. And so, just looking at my very messy notes here. So the key point, though, is, and thank goodness to this, is we're all becoming more familiar with what the issues are. And as Emily knows, and every lawyer in this room knows, if you know what you're facing when you create a business deal or a commercial transaction or a commercial relationship, you can deal with those issues up front in your dealings. And so this applies to transparency as well. We now know what the climate change issues are. We know what the carbon issues are. And because we know what they are, we can actually take steps to at least mitigate risk and raise those with the investors. So if you have an investment that's operating right now that has carbon issues or climate change issues, you know, the sooner the better to come up with a collaborative way of dealing with those issues, whether it's a phase out or a change in technology or whatever it is, the better. Get it on the record. And I mentioned at the very outset that you know, when you're defending claims, there's all these great theories you can raise. And I've been involved in a number of cases where as we go through the document production process, we find all of these great reasons why this investment should have been stopped. But none of those fit into the reason why it was stopped. So it's the facts surrounding the decision that affects the investment that become relevant. So we now know what those facts are. And at the time investments are made, or even while they are operating, now is the time to put those facts on the record, and they could really help you in the future if you have to defend a case. Now, there's one point I didn't get to is another strategy that we use where, you know, the case on the merits is very difficult to win. In fact, it could be a complete loser. However, we still fight really hard on the merits. And why do we do that? It's because we're laying themes, we're laying facts, we're laying issues that could help us on damages. And so right now, if you've got ongoing operations, ongoing investments, and there's a risk that sometime in the future, this could end up in an arbitration, now's the time to raise those facts, put them on the record, because if they don't help you on the merits, they could really help you on damages. And, you know, as we know with the damages claims, they're just going through the roof right now. And anything you can create on a factual basis, and again, these tribunals, they look at the factual record. What is the factual record? And there may be some great arguments and things to make, but if the facts don't back it up, you can't do that. So, Tracy, I hope that helps on the transparency question. Agatha, you asked a question about the contractualizing of investment disputes. And so I think I'll defer to Emily to give more details on that, because she's experienced on both sides of these things, both on the contractualization side and on the ISDS disputes. But from my perspective, those contracts could be very helpful as facts in a dispute. And, you know, what Emily was talking about, all I could think about is, boy, I wish in some of my cases we had those contracts with those clauses, because they will become relevant facts on the record. And again, going back to the basic strategy, if you're going to lose on the merits, build a factual basis for the damages. And we've had cases where the claims were massive, and they were very worrisome. And if you took a traditional approach to defending the damages, it would be a big damages award. And yet we, you know, we always quote a range, and we actually achieved in one case the bottom of the range. And why was that? Because the equities of the issues we raised in the merits, which technically, you know, you could argue weren't relevant to damages, became relevant, and that's how we ended up with a great result from the case. So, you know, these contracts will become very important going forward. You know, I invite Emily to maybe give some more insights into the crossover with ISDS and whether those contractual clauses are undermining the ISDS process. The question about third-party funding, I couldn't write quick enough, but I've got some scratches here that I'll go through, and please let me know if I've missed anything. Well, first of all, we're encountering more and more third-party funding, and it's actually becoming really problematic. So when we started doing these cases, you know, the claimant side, they'd run about $3 million in expenses or fees for lawyers and for experts. And this was sort of a natural filter for bringing a case. You know, the claimant has to pay the cash, and you know, they're facing $3 million. Yeah, they could get 10 experts, but you know, are they really going to want to pay $10 million rather than 3? And so that, for many, many years, was extremely helpful to both sides. In the early days as well, something to remember is that in arbitrations, the loser pays the legal fees for the other side. And so in the early days, it was 100%. And as time has gone on, the delta, or the difference between what the respondent's side expenses are and the claimant side, just got larger and larger. So you know, over time, at least in my experience with the cases we've done, the damages that the state has to pay to the other side have been reduced below what the other side is asking for. Now, how does third-party funding change that? So for many, many years, it was sort of standard, roughly about $3 to $4 million for the claimant side. Now it's over 20 or more. And worse than that, the standard practice is to have roughly 3 experts in a case. So you've got the subject matter expert, so they understand what the measure at issue is. You've got the damages expert, and then you'll have another expert that's sort of in between. It's sort of causal link kind of expert. So that's 3, and for years and years and years, that was the standard. With third-party funding, it's insane. So we've had one case where We filed 3 expert reports in our counter memorial, and the claimant came back with, I think it was 12 expert reports in reply. And there's no way a government can afford to rebut have a dozen experts. So experts in all these various little areas that, we didn't think were relevant, but there's the evidence and we need to do something about it. And so third-party funding has really ramped up the cost. And, we're seeing, it's not uncommon now to see the fees and costs of the claimants to be over 20 million US in one of these cases. And so third-party funding has really done that. Will it trigger more cases? I have that note here for one of your questions. Absolutely. We've had this filter that really limits long shot cases. So if you're a company, you're the president of a company, and you've got to invest in this case, and it's going to cost you $10 million, you're going to think really hard about whether you do it or not, because no matter what happens in these cases, they're always uncertain. One of the things I loved about WTO litigation is the quality of the decision making was incredible. And more than that, they had this secretariat that supported the panels in the appellate body. And it wasn't just administrative support. So in investor state arbitration, you get administrative support, very high quality administrative support, but you don't have the substantive support. Whereas in the WTO, there was this consistency. So it was like an institution. So the secretariats in both the appellate body and the panels were incredible at keeping things level. And you don't have that in investor state. And so, when you get situations where cases that probably shouldn't go forward are going forward, you've got to take them seriously as a state, because you never know what the outcome's going to be. I think, did I cover all of your points? Yeah, okay. Sorry for droning on.
1 minute. 3 questions, 1 minute, easy. To Agata's point about the contractualization of investment protection clauses, I think the short answer is yes. You do see that, and you will see more of that given the uncertainty around certain treaty regimes, and that will very much depend on the jurisdictions that are involved. What level of risk there is and how you want to compensate that. I think there's more and more arbitrations at the other end you see involving states and state-owned entities, and that could be a part of that that's being built into the contract. Whether an investor is able to secure such a contract will depend on their bargaining power, the kind of contract as well. But as we heard from Greg, maybe states also have an interest in limiting the amount of damages that might arise out of a transaction. So there might be some different dynamics there to take into account. In terms of the duty of due diligence and how that overlaps with treaty obligations, I think it's a really interesting question, and one which maybe some people can explore in more detail, because you do have sort of due diligence clauses in treaties. Whether that's talking about the same kind of due diligence you'll find in a contract, you really have to look at the wording of a specific contract, the wording of a specific treaty. But as I said, the substantive content of what is due diligence and what that means in practice is a bit of an open question. Also, the fact that contractual cases under commercial arbitrations are going to be confidential, so there's not a lot of public discussion yet about what a contractual clause might mean. I think the natural step is going to be to import soft law standards into our understanding of those contractual clauses, and that may also be the case for some of these treaty obligations. So you may see some links or some connections between them, but that's not always going to be the case because every contract is a different beast, which is the fun thing. On Alex's point about the metrics, I think this is a really good point. It's really notoriously difficult to pin down what is E, S, and G, what elements are you trying to measure, what standards apply, and I think that's why it's important when you have a contractual arrangement to be very precise about what the standards are, what metrics have to be complied with, and how do you measure them. I think there's many risks of not doing that properly, especially if you have a chain of contracts and very broadly worded clauses. And I think there's going to be a more and more ESG auditing according to standard setting, where hopefully we do manage to harmonize some of those metrics. But going back to Greg's point about expert evidence, I think this area is going to be a growing area of expert evidence in dispute proceedings, where you have sort of experts opining on what are the ESG metrics and whether they are met, how they are met. So interesting developments to watch.
Thank you, Counsel. Very concise and precise. I'm sure there would have been more answers, more questions, but yeah, we need to stick to the time. A big thank you to our panelists for the insight and to all of you for your attention and participation. And please join me in giving our panelists a warm round of applause to close this session. Thank you.